Hi, this is Dr. Tracey McCarthy, psychologist, attorney, and educator. This video is a follow-up to the video on insanity and the insanity defense. Here we will be addressing the much talked about issue of competence. Competence in legal terms means mental capacity to participate in a legal process or an activity. For instance, competence is specific to a particular action, such as when you're signing a contract or drafting a will, consenting to medical treatment, or in the criminal case, being executed, getting married, or competence to stand trial. The question of competence generally revolves around a person's mental functional capacity. So competence to stand trial is often confused with the insanity defense. The two, however, involve distinct legal and psychological issues. Competency, as with insanity, involves the mental state of the defendant in a criminal trial. However, unlike insanity, competence involves the state of mind after the crime. This could include competence to plead. Most of the time, though, what the public is made aware of is competence to stand trial. Now, competence is not about criminal culpability. It instead addresses the issue of the defendant's mental state during criminal trial proceedings. The issue we are examining is the issue of competence to stand trial specifically. With competence, we are not concerned with criminal responsibility at all. The questions revolve around the extent to which the defendant is capable of effectively assisting his or her counsel with effectively assisting the defendant. In other words, the standard for determining competence in criminal proceedings is, can the defendant assist the attorney with things such as trial preparation, making informed decisions regarding accepting or rejecting a plea. There are also important questions as to whether or not the defendant is able to understand instructions, understand the roles of the members of the court, understand the trial process itself, and understand the nature of the charges against the defendant. To make this determination, psychological or psychiatric evaluation is conducted on the individual. This may involve interviewing, mental status examinations, and psychological testing to assess, among other issues, intellectual functioning and actual competence. So competency essentially deals with the defendant's present condition versus past conditions, as with the insanity defense. If a defendant has been deemed incompetent to stand trial, the defendant may be rehabilitated in order to assist the defendant with becoming competent to stand trial. This typically involves some form of psychiatric or psychological intervention if possible. In some cases, however, nothing can be done to assist the defendant to become competent. Psychological challenges that are likely to raise the issue of competence involve things like psychosis, behavioral dysregulation disorders, and disorders related to deficits in cognitive functioning, such as intellectual disability or neurocognitive disorders. Even a severe learning disability can impede a person's ability to effectively work with legal counsel in their defense. Any emotional, behavioral, or cognitive challenge, however, may be raised in considerations of competence to stand trial. Also, both the issue of insanity and the issue of competence may be raised in the same criminal defense. A pivotal case to look at regarding competence was the Dusky case of 1960. Okay, that is a general look at the issue of competence to stand trial. We hope you found the material helpful, and we thank you for stopping by. We look forward to seeing you again soon as we provide upcoming content on a variety of psychological, forensic, and organizational topics.